Hi, and welcome to Academic Compliance Academy of Anti-Money Laundering. So in this video, I'm going to talk about the latest case C-37/20 of the 22nd of November 2022, because it is the first time that we've seen the ECJ really redline the boundaries between GDPR and the Charter of Fundamental Rights versus anti-money laundering regulation. So there were actually two cases, but I'm just going to highlight one of them. So it was a Luxembourg company, and the beneficial owners felt that their fundamental rights were being violated because of the register of beneficial ownership data. So to really understand the problem, we must look back at not the fifth directive, which is the directive in the case and in the ruling, but the fourth directive. We need the history behind it. In the AMLD4, you could have the beneficial ownership data should be accessible for any competent authority and FIU, the obliged entities, and any person or organization that can demonstrate a legitimate interest. The information that should be accessible for the last bracket of any person and organization with a legitimate interest should be at least the name, the month and year of birth, the nationality, country of residence, the beneficial owner, as well as the nature and extent of the beneficial interest held. So there was some member state having problems with the interpretation of legitimate interest, and therefore there was a change to the next directive, AMLD5. And here, the change in the regulation was that it became accessible in all cases, and now look at point C, to any member of the general public. So here we have some sensitive personal data that now has become accessible for the general public. And this is what the case is about. So here we will see what the court really thinks of this situation, this transformation going from one directive to another, and the essential preamble or paragraph is 85. Here we can see that the court states that if you compare the two, so AMLD4 and AMLD5, there is a shift from going that in the first one, it is only competent authorities, the FIU, etc., and people with a legitimate interest that can have access to this data. And when you change that to be a general public access, you go further in the violation of privacy and the protection of fundamental rights. And here, what is essential about this part of the ruling is that the court states that this transitioning with increased access happens without any increased benefits. So you raised the interference of fundamental rights without any benefits. And this is why the ruling becomes what the ruling is, that this new point C of the AMLD5 is declared invalid because it provides member state information of companies and other legal entities to the general public, and these information should only be used when we're talking about an actual AML risk or an actual money laundering risk. So if we look at the coming regulation, the AMLD6, here we have the same wording as in the AMLD5, that any member of the general public has access. So we must expect to some extent that this wording will be changed, and this is one of the key points from this ruling. The wording of AMLD6 will probably be changed and go back not to 5 but to AMLD4, because this is what, when you read the court ruling, here is a legit, here the AMLD4 really outlines the barrier between, and it is acceptable in accordance to the fundamental rights and GDPR. At the same time, we must acknowledge that one of the conclusions with this ruling is also that the legality of the public records of beneficial ownership data is gone. Well, we have already seen member states taking down their public records, and we must acknowledge that this is actually right until we hear more from the EU. This is actually what they should be doing because the legality has gone. So, of course, there will still be access to the registers of obliged entities, the competent authorities, and anyone with a legitimate reason. This is stated in the ruling. So, this is a good example of the key element. The key element when we're talking about the barrier between AML and GDPR. So, when can we go in and use data that might be protected by the Charter or GDPR in terms of fighting money laundering? Well, we can only do this when there is an inherent risk. When we see a risk of money laundering, that is where we can't violate this protection of privacy and the fundamental rights, because that is in the search for criminals, that is in the search for money launderers, and that is the only case where we can go in when we want to investigate and we have a suspicion of money laundering happening. So there needs to be a risk. And this is also in line with the ruling, because anyone in the public, giving them access to private data, there is no risk apparent. So we need that only the parties that actually have a legitimate reasoning should have access, and that access should be applied and connected to some kind of money laundering risk. So this was my version and comment on the latest ruling. Stay tuned, subscribe to the channel, and let's talk much more about money laundering.